Good morning, Alok ji. When did you do your law?
I completed my LLB honors in the year 2021, sir.
21. All right. Post that, what did you do?
I completed my postgraduate from National Law University, Delhi, with a specialization in Constitution and Criminal Law. And currently, I am pursuing my doctorate from National Law Institute, University, Bhopal.
Okay. All right. So, are you a first generation law graduate?
Yes, sir. I am a first graduate. Sir.
Okay. So, what? All right. So, what is doctrine of part performance?
Doctrine of part performance has prescribed in the Transfer of Property Act, and as I can remember, it is section 52 of the same, and I am not able to recall it right now.
52 probably is lis pendens.
Sorry, sir. Sorry.
53A is the correct provision of law.
Yes, sir. Sorry.
All right. Is it necessary to plead a fact before seeking to prove it by way of evidence?
Sir, please pardon, sir. Repeat, sir.
Is it necessary to plead any fact in a court of law in your pleadings, whether you are a plaintiff or you are a defendant?
No,
before leading evidence during the stage of trial before the court.
So in a civil proceeding, only material facts are to be disclosed, and it is not necessary to plead any evidentiary fact on the basis of which any fact in issue is to be proved.
So all right. So you are trying to say that material facts have to be pleaded.
Yes, sir.
Only then a party can produce evidence, relevant evidence for proving the same.
Yes, sir.
All right. What is the standard of proof in criminal and civil cases?
The standard of proof in criminal cases is for the prosecution is beyond reasonable doubt, and in civil proceedings it is mere preponderance of probability, sir.
In whose favor?
In criminal trial, all proceedings have been proved to preponderance of probability, whereas in criminal case it is beyond reasonable doubt. Whereas if accused has to prove everything in criminal trial generally, then the burden is of preponderance of probability. It is lower than that of beyond reasonable doubt.
All right. Then what is double jeopardy? Principle of double jeopardy?
Principle of double jeopardy can be found in Article 20, Clause 2 of the Indian Constitution, and it provides that if any person has been priorly acquitted or convicted on the same facts, then the same person cannot be tried or punished subsequently.
All right. Are you sure that it talks of both acquittal and conviction? Article 20, subclause clause 2? Or does it talk of only conviction, not acquittal?
It basically provides for if any person has been tried earlier, but when we read with section 300 of Code of Criminal Procedure, then it basically relates to principle of autrefois convict or autrefois acquit.
So therefore, constitutional provision only talks of autrefois convict.
Yes, sir.
And not autrefois acquit.
Yes, sir.
300 deals with both, whereas
yes,
Article 20 clause 2 only deals with the earlier one.
Yes, sir.
And then it has to be a trial for a criminal offense.
Yes.
All right. Is this rule of law or doctrine covered in any other statutory enactment other than CRPC?
I can't recall it.
All right. It is General Clauses Act also.
Okay.
All right. Suppose if there is a juvenile which is produced in a court, criminal court, then under which provision of law his uh, his age is to be determined, and on what documents?
So Section 94 of the Juvenile Justice Act basically relates to the same, and it provides 4 categories of document. The first is any document of her matriculation or his certificate matriculation where he has gone to school. Further, any birth certificate obtained from any local body or municipality, and subsequently, if any of these cannot be achieved, cannot be brought, then ossification test can also be done. So.
All right, all right, all right. Good. Then, does the statute CRPC and maybe it's that BNSS, do they contain any provision or do they contemplate trial of an accused in his absence?
Yes, sir. There are provisions regarding the same. The first is, as far as I can remember, it is Section 205 of the Code First, which provides for the same. And the second is Section 206 also, which provides that in petty cases, also the person can be tried in its absence. And it is in 206 as well. He can plead guilty and remit the amount of fine through a postcard or through advocate as well, sir.
All right. A short intervention. Section 299 deals with such a situation when accused is a PO. 317 deals with such a situation when accused continuously interrupts the proceedings. 318 says when he is of unsound mind, then it has to be stopped and then his treatment has got to be done. All right. Thank you. Thank you. Next, please.
I want to ask you a question about criminal law. Can you tell me the difference between the offense of cheating and criminal misappropriation and criminal breach of trust?
So provisions regarding criminal misappropriation of property and criminal breach of trust can be were in Section 403 and 405 of the Indian Penal Code. I have studied the new law, but I am not able to recall the sections. So basically, both of the sections deal with movable property, and the basic difference between criminal misappropriation and breach of trust is that in criminal breach of trust, there is any sort of entrustment of the property given to the person, whereas in criminal misappropriation of property, the person finds any property, and at that time the innocent is not a dishonest one, but later the person misappropriates the same to his own use. So both of these offenses deal with mens rea of dishonestly, whereas cheating, which was provided in Section 415, deals with another type of mens rea, which is fraudulently. Sorry, I can recall this.
Normally, when police files charge sheets in courts, they charge a person under both the sections of cheating and criminal breach of trust.
Yes, sir.
Can you tell me what is the difference between the two? When does a case fall under cheating and when it falls under criminal breach of trust? What is the distinguishing line and feature which separates the two? Because what the ingredients are different in both the cases.
Yes, sir.
A person cannot be charged under. So what is special and distinguishing feature between the two? A person who has committed cheating, why he can't be charged under for an offense of criminal breach of trust? Or a person who has committed breach of trust, criminal breach of trust, cannot be charged for an offense of cheating? What distinguishes the two?
The first aspect is that of mens rea. In the criminal breach of trust, it is dishonestly, and in cheating, it is fraudulently. The second is with regard to entrustment. In the criminal breach of trust, there is an entrustment of the property, whereas in cheating, there is not a entrustment in the property. So these are the two distinctions that I can recall right now, sir.
Okay. And in the offense of cheating, is loss to the complainant is essential?
As far I can remember, it is not essential, sir.
It is not essential.
Yes.
Loss in terms of money or loss in other terms.
Sorry,
Without
sir,
loss of money, can also an
Yes.
offense of cheating be made out against a person, even if there is no monetary loss?
I can't remember it. Yes.
Is the definition of fraud under Companies Act different from definition of cheating under Indian Penal Code or BNSS?
Sir, I have not read cheating specifically, sir.
Okay, I give you a situation. Suppose an employer gives an ad for employing some manager in a company. Okay.
Yes, sir.
And manager claims a lot of things that he's capable of, about his performance, about his connections, about that he can generate a lot of revenue for the company, and he's employed on that basis by a company. And after joining this person, the employer comes to know that he was all the promises and claims made by the employee were false. And on top of it, he's indulging in raising fake invoices on behalf of the company to show as if he has done some sales for the company, generated some revenue, and adding insult to injury, he also deposits GST on behalf of the employer when there is no sale actually.
Yes, sir.
Fake revenue generation, fake invoicing. Okay. And when this employee is caught by the employer that you are indulging in fraudulent activities, then he threatens to lodge a complaint against him in police. Then they reach a settlement. The employee says, okay, because in order to, believing the employer hires many more employees, hires and rents extra space. So he spends lakhs of rupees on the basis of promises made by the employee.
Yes,
Okay.
sir.
So the loss to the employer is not direct, but
Yes.
indirect. Okay. And then finally, when the employee is threatened with action, they reach a settlement. Employee says, okay, I made profits on the sly. I fooled you. There was no actual business generated by me. And he gives checks of, say, 2 crores of rupees as part of the settlement signed by the employee only. Okay. And on the basis of these checks and settlement, the employer files a case of negotiable instruments under section 138 and 142 on the basis of bounce checks given by this employee.
Yes, sir.
Okay. This is one part of it. And the employee takes a defense that he was forced to sign all these checks under coercion.
Yes,
He never voluntarily gave these checks.
Yes, sir.
So what is your stand? Where does the employee stand and where does the employer stand?
So in these, there can be 3 offenses that can be formed on either sides. And with regard to the first offense, cheating can amount to in case there is a negligible loss to the employer as well. And on this, there is a Supreme Court, there is a case as well in which there was a LIC agent who used the papers of the company and generated fake accounts. And in this, the court said that even the loss of papers cost to the person would amount to cheating. The further, if any person threats you that I will take any criminal action against you, then it is also an offense. And as far I can remember, it is a type of extortion. So no person can use law to threaten someone. So it is also an offense. And further,
Are you sure? If law gives a person some legal right and he says that I will take action under law,
yes, sir.
Can this amount to extortion? No.
If
it is only threat of false prosecution, false implication in a criminal case, that can amount to extortion, not this.
Okay, sorry.
If I exercise my legal right to take action against a person somebody issues a check based on a settlement, after realizing that some fraud has been committed that person, even though in the eyes of law, no financial loss directly may have been caused to the employer. In this case, indirect loss was committed.
Yes, sir.
The employer has incurred losses in the form of, because employer, believing the employee, he hires many more employees, takes on rent, large area, spends a lot of money. So it is indirect loss. But under the Companies Act, this is not necessary. For an offense of cheating,
Yeah.
no financial loss is required. If you are promising something with the intent to deceive, your initial intention is to cheat, the offense of cheating is made out.
Yes, sir.
Employer may or may not have suffered financial loss directly or indirectly, even though employer has suffered loss in this case indirectly also. But under the Companies Act, financial loss is not a must. If you are making a person do something which he would not have done otherwise in normal course of business, on the basis of false promises made based on criminal intent, the offense of cheating can be made against a person. But in this case, according to you, whether it is a case of cheating or it's a case of criminal breach of trust, can this section of criminal breach of trust also apply to this person or not?
I can't answer. I cannot recall, sir.
Well, because this person is an employee, and there
Yes.
is section 408 of IPC.
Yes.
An employee can be prosecuted for committing criminal breach of trust in such a situation. Okay.
Yes.
And she has misappropriated, like depositing cash and other property of the company was entrusted to her, which she misappropriated. Lot of property of the company she sold on the sly.
Yes.
So it's a situation where both sections can, but you have to have clarity on this, under which section, if this case comes to you in a court of law and you are a judge, which side will you take?
So by far, there is an entrustment, then there is a master-servant relationship, then it can fall under criminal breach of trust. Yes, sir.
Yes. Okay, fine. That's it for me.
Yes, Alokji.
Yes.
From where did you pursue your LLB and LLM?
I pursue my LLB from University of Allahabad and LLM from National University, Delhi.
Okay. Is there any act which governs the universities?
So by far in University of Allahabad, it was established in 1877, but after in the year 2005, it became a central university. And by
No, I'm asking that is there any particular act which governs the universities?
Yes,
Is
sir.
there any UGC Act?
Yes, sir. UGC Act basically recognizes the same, sir.
Okay. And what do you understand by usufructory mortgage?
In a usufructory mortgage, the mortgagee is given basically the rights to utilize the usufruct, which is the interest, rent, or profits deriving from the immovable property against the mortgage money or the interest thereof, and he can basically utilize the same till the same is equalized.
Are you sure that the usufructs shall be in the lieu of the interest and the principal amount? Or only the interest or only the principal amount?
It may be with regard to the interest or the money, sir.
Okay. Do read the barrect. एक बार इसको check करना. Okay. Let's come to criminal procedure. Okay. IPC. What is the difference between culpable homicide and culpable homicide not amounting to murder? Alok, there is a network issue, I guess.
Yes, ma'am. Is it okay, ma'am?
Yeah. Now it's absolutely fine. Yes. So the question was, what is the difference between culpable homicide and culpable homicide not amounting to murder?
The both are the same, ma'am.
Both are same. Are you sure?
Yes, ma'am.
Then what are the exceptions under murder? What are they called?
I have listed down the exceptions, ma'am.
Yes, you can read out the exceptions, no problem. But I'm stating, what I'm asking is that there are 5 exceptions given under your murder, right?
Yes.
Section number 300, there are 5 exceptions. So what will those exceptions fall into the category of? Will they be called as murder? Will they be called as culpable homicide? Or will they be called as culpable homicide not amounting to murder?
So basically, section 299 can be understood as culpable homicide not amounting to murder, and section 300 shall be termed as culpable homicide amounting to murder. If any case falls in any of the exceptions, then the case will be of culpable homicide not amounting to murder.
If any murder falls into the exceptions of 300, it
Yes.
shall be termed as
Culpable homicide not amounting to murder.
not amounting to murder. Isn't it different from section 299, which is defined as culpable homicide?
It is same, ma'am.
It is same.
Yes, ma'am.
When you read the exceptions, the opening line itself says that culpable homicide is not murder. So
Yes.
that means the 5 exceptions of murder are termed as culpable homicide not amounting to murder, and culpable homicide is only that much which is defined under 299, and murder is only that much which is given under your section 300. Okay. But the punishment of culpable homicide and culpable homicide not amounting to murder is given under the same section.
Yes.
Which is that section?
It is in section 304, ma'am.
304.
Yes, ma'am.
Okay, good. Now the next question is that killing of a child in mother's womb will amount to culpable homicide or not?
No, ma'am, it would not amount to culpable homicide not amounting to murder.
Why?
It has been laid down in an exception of section 299. So basically, if any body
299 do not have any exceptions. It has explanations.
in the explanation that if any part of the body of the child is outside, has come outside, then it may amount to culpable homicide. Whereas if any part is not outside, then it will only lead to causing miscarriage or abortion.
Okay, so we can say that if the child is in mother's womb and the death of the child has been caused, we can call it as feticide because it is not a human being.
Provisions relating to 312 to 317 can be attracted.
Okay, very good. What is the difference between agreement and a contract?
So an agreement, any agreement enforceable by the law is a contract. So basically, when an agreement passes the stage of enforceability, or it has enforceability, then it may amount to contract. So agreement is a wider concept, whereas contract is a subspecies of the same.
Okay, so can we conclude that every contract is an agreement, but every agreement is not a contract?
Yes, ma'am, it can be said that.
Okay. And what are the essentialities of legal enforceability? What all things can be included in the term legal enforceability where the agreement converts into a contract? Is there any specific section?
Section 10 of the Indian Contract Act basically deals with the same, which provides that there should be free consent and the agreement should be for a lawful object, lawful consideration. There shall be intention to create a legal relationship, etc.
Okay. You use the word consideration. Can there be an agreement without consideration? And what will be the status of such agreement?
Generally, any agreement or contract, ma'am?
Agreement without consideration. Can there be an agreement without consideration? If
No,
yes, and under which section?
Section 25 basically provides that consideration is necessary for the same. But there are 3 exceptions. If there is any past voluntary service, or basically there is any time barred debt, etc., then there can be an agreement without consideration as well.
Okay, and what is the legal status of the agreement without consideration? Is it a void agreement, void contract, or voidable contract?
It is a void contract.
Okay, and why time barred debt is considered as a valid agreement even without consideration? Is there any logic?
The basic logic that can be derived is that when we go to the Limitation Act, then after prescribing the end of prescribed period of limitation, the remedy, as the remedy of enforcing any debt has been lost, but it can be recovered in any other way. So I think in order to facilitate the same, their time bar debt has been made an exception.
Okay. I think we can wind up with the interview, and now the panel will proceed to give you the feedbacks. Okay, Alokji?
Okay, ma'am.
You come from which place?
Prayagraj, sir.
Prayagraj. Okay, Allahabad, so to say, UP. So थोड़ा सा इन दिल्ली अब जो भी स्थिति है, अब यूपी में शायद वहाँ जो लैंग्वेज ऑफ डिस्ट्रिक्ट कोर्ट है वो भी शायद हिंदी है, मुझे लगता है. और बट हियर इन दिल्ली you have to slightly work on your language. Please do it. It is possible. I come from a Hindi medium school. I studied I started learning English only at the age when I entered 6th standard.
Yes, sir.
So you need a conscious effort. Please do it. Secondly, there is a subtle difference between I do not remember, I do not recall, or I do not know. You can recall or remember something when you had known it earlier.
Yes, sir.
At the moment, you are not able to recall because of lapse of time. But there are certain things which one does not know.
Okay.
So it is precisely, you should say, I do not know. I'm sorry. That's okay. It happens in life. One may not be knowing so many things. Just work on it, according to me. That is my advice to you, because your academic record appears to be good. Because a law student pursuing PhD,
Yes, sir.
it's a scholarly act actually.
Yes,
So, थोड़ा सा जब स्टेट से बाहर निकलेंगे तो थोड़ा सा क्योंकि एक्सेप्टेबिलिटी सब जगह की होनी चाहिए, क्योंकि दिल्ली में सब तरह के लोग आते हैं, यूपी से भी बहुत आए हैं, बिहार से भी आए हैं, हिमाचल, सब जगह से आते हैं. थोड़ा सा वर्क ऑन इट intentionally with a conscious effort, you will be able to do it. That's my advice to you. Thank you very much.
Okay, Alokji, I would say that you are good, but I would say there is always scope for improvement.
Yes, sir.
You know, and so keep working on it, and
Yes,
best
sir.
wishes.
Right, sir. Actually, the thing is, certain aspects I have not studied. For example, cheating and forgery, they are the two offenses of IPC that I have not studied.
It's a very complex thing. Even police authorities have not been able to understand, and there's a lot of confusion about it.
See,
Anyway,
the Honorable Supreme Court had to tell this in 2024, that police has been committing this mistake since when we do not know, but even in 2024, they would put 420 read with 405 together.
Yes, sir.
Which
because
is
of
legally
confusion.
legally
They are
not
never
acceptable.
sure.
Yes, sir.
Anyway, thank you.
Okay.
Yes.
All of it.
Alok, first of all, it can never be expected by the panel that each and every student knows each and every provision of the PEREC. So it's absolutely fine that you forget things, you say sorry, there is no issue. If you say sorry more than 50% of the times also, there is no issue, because interview is just an examination of your honesty and confidence. Second important thing, as Pramod sir already highlighted that thing, that there is a way to communicate your sorry.
Okay.
So you have to communicate your sorry in a very sophisticated manner. है ना, एकदम से होता है समय को नहीं पता, है ना, एक बहुत sophisticated तरीके से, sorry sir, I beg for my negligence, I'll definitely go and read this particular provision. Okay. Second thing, जैसे आप अभी smile कर रहे हैं, this was required during the interview. That is your time. Charm होना चाहिए चेहरे पे. You were looking very tense and demotivated. Okay.
Yes, sir.
आई एम टेलिंग यू, मेरे खुद के इंटरव्यू के एक्सपीरियंस से आप कई बार सॉरी बोलेंगे, बट चार्म एंड ऑरा ऐसा होना चाहिए दैट दे फील लाइक कि ऐसे पॉजिटिव एनर्जीज को हम जज बनाएं. ट्रेनिंग में आपको बहुत चीजें सिखाई जाएगी. एंड लास्टली, एज पदम सर राइटली हाईलाइटेड दिस थिंग विद रिस्पेक्ट टू द लैंग्वेज एंड द टोन, एंड इसी में मैं एक और चीज ऐड करना चाहूंगी, डोंट ईट द वर्ड्स. है ना, वो शब्द आपके कुछ शब्द है ना मुंह में रह जा रहे हैं, डोंट जम्बल अप देम. आराम से खूब टाइम मिलेगा आपको, दैट इज योर टाइम, जस्ट यू एंड द पैनल विल बी देयर। सो एक एक वर्ड अच्छे से कम्युनिकेट हो आराम से, और जितना आराम से आप अपना स्टेटमेंट वहां डिलीवर करेंगे उतना ही समय आपको मिलेगा अपने माइंड में टू फ्रेम द नेक्स्ट स्टेटमेंट, टू फ्रेम द नेक्स्ट कॉन्सेप्ट। ओके, एंड बी रेडी फॉर दिस थिंग कि पैनल से ऐसे बहुत सारे क्वेश्चंस आएंगे अबाउट विच यू लिटरली हैव नो आइडिया, एंड इट्स एब्सोल्युटली फाइन दैट यू डोंट नो मेनी थिंग्स, बिकॉज मेंस में आप ये चीज ऑलरेडी प्रूव कर चुके हो। सो बी ऑनेस्ट, कॉन्फिडेंट, एंड वोकैब जो है वो एकदम क्लियर हो, स्पष्ट हो। ओके,
Okay, thank you.
ऑल द बेस्ट।